waive oral argument to use as you please.
Thank
Ready
you,
to
Honor.
proceed.
Thank you, Your Honor. May it please the court. I am Alan Bevick. I'm here representing the defendant, appellant in this matter, Anthony Humphries. This is an appellate of a criminal conviction for charges of carrying concealed weapons, weapons under disability, and aggravated menacing. Mr. Humphries challenges the conviction based on grounds of insufficiency and manifest weight. Particularly, there is little to no evidence to support the finding that he was in possession of a gun. The sole evidence in that regard is the victim's witness testimony, which is uncredible, based upon he's an unreliable witness. There were independent, unbiased witnesses who testified that they saw no gun present. There was no gun found on Mr. Humphries' person at the time of his arrest. He was challenging the victim for removing siding from the house at 644 Merton, and that, by all accounts, that conversation became heated between the two. I believe both parties called 911. And as far as the evidence supports, I think to get to a position of beyond a reasonable doubt is impossible based on that testimony. I think that at a minimum, the credible witness testimony of the independent witnesses seriously challenge and raise manifest weight issue as to the testimony of the victim regarding Mr. Humphries' possession of a firearm at that time. The gun that was found at the scene was not in the possession or registered to Mr. Humphries. It was to his wife, Miss Kenny Williams Humphries, and it was never observed to have been in possession of Mr. Humphries by any
Where was
party.
the car in relation to where this all occurred?
And the gun was found under the hood of an SUV, and that, by all accounts, that car was in the backyard of Mr. Humphries' house. It was their motor vehicle, but it was also within line of sight of the police officers throughout the entirety. I believe the testimony supports that.
Well, you say the car was in the backyard?
I believe that's
And how was that in relation to where the siding was being disturbed?
My understanding from the testimony and viewing the maps online are that they have adjoining, I think they have adjoining backyards. I think these are lots on a corner on Merton and Inman. And
So this didn't occur on the street, it occurred in the back?
it occurred,
property?
I believe the testimony supports that Mr. Humphries walked across from his house. It's unclear whether he walked down the street or through his backyard to get to Merton. There is no testimony regarding how that encounter arose. Obviously, Mr. Humphries did not take the stand, nor Ms. Humphries. The two independent witnesses saw an argument arise. I believe the victim stated that Mr. Humphries came up to them, but how he approached them is unclear. I think there was no indication that, well, what is significant in the record is that no police officer, at the time the police officers arrived, Mr. Humphries was not there. No one observed Ms. Humphries or any other person place the gun in that SUV. It was in line of sight to the officers. They testified to that they could have, if anyone had approached the car, they would have seen that. There's no indication that they tried to.
I'm not sure I understand. How would they have seen it if it's under the hood?
No one saw anyone place that gun under the hood, and to be
And
clear.
this was a bench trial, right?
It was a jury trial.
A jury trial, okay. And couldn't remember, the one we just had before was much strong, yes.
Yes.
Anyway, the point is, couldn't the jury, the finder in fact, consider that the gun was under the hood? That's a very unusual place to have a gun.
It's an unusual place to have a gun, I don't dispute that, but that I think you go beyond the point of circumstantial evidence into the point of conjecture to with no evidence, with no, and we're talking about an investigation that started following a 911 call. My experience is when and again, I don't know what's in the record here, but is that when a gun is involved in a 911 call, the response tends to be very quick. So we're not talking about a great deal of time between notification or this incident and whatever time frame we're talking about before the investigation to commence. I think we're at a point where you've moved past a circumstantial argument to conjecture as to why that gun got there, how it got there, without any support for, yes, it's not a place to have a gun, yes, it's a bad idea, it does, but there's any number of reasons. The gun was registered to Ms. Williams, obviously, Williams, Humphries.
And the car was not at the scene, not where it, when the police arrived, the car was not there, but Mr. Humphries was?
My understanding of the record is that the car was there, but Mr. Humphries was not, that he had left in a different vehicle.
Oh, okay.
And he arrived back at the scene later. And that the car, the SUV in which the gun was found was at the scene the entire time. It did not move, they didn't drive to hide the gun and then bring it back. There was no, I believe the gun was located under the hood of a car that was at the location the entire time.
And he is convicted of carrying a concealed weapon?
Yes, he's convicted of carrying a concealed weapon. I believe that, without getting too far into it, concealment is something of an issue. I think that they said he went, that the argument or the testimony of the victim is that he left and came back with the firearm. I'm not sure how we reached concealment there. But he's charged with weapons under disability, and he's charged with aggravated menacing related to the firearm and a credible threat of harm to him as a family member. And those are the elements I dispute at this point, based on, because all of those stem from this unsupportable evidence or testimony that he was holding a firearm. And
did the other individual who was with, did he decease because for other purposes prior to the trial? There's only one of the victims.
There's only one victim who testified, and I don't know why the other person did not testify.
Okay. There's some, it says the sole surviving victim.
If he was deceased, it's unrelated to this incident. But I don't believe they didn't attempt to admit any evidence based on his unavailability.
Just the one?
Yeah. So, I think that is the essence of the argument here. As I said, both at an insufficiency level and at an challenge to the manifest weight. I think all of this stems from the failure to demonstrate credibly that Mr. Humphries was in possession of a firearm. If there are no further questions,
I don't believe there are. Thank you for your argument, and the court will take the matter under advisement and issue a written opinion that will be sent to both sides as well as release evidence.
thank you very much,
Thank
Your
you.
Honor.